afternoon part of the continuation of the symposium called The Enduring Value of the Rome Statute to Humanity. This afternoon's program is consisting of two panel discussions. We will start first with the first panel discussion, and after the break it will be continued with a second panel discussion. The first panel will focus on the impact of the judicial process. However, before we start with the panel discussions, we'll first have opening remarks by the President of the Assembly of States Parties, President Ogon Kwan, followed by the keynote address by former ICC President Sang-Yoon Song. I would now first like to invite President of the ASP to provide the opening remarks.
Thank you. Distinguished guests, Excellencies, ladies and gentlemen, it is a pleasure to welcome you here today. Today's commemoration will signal a renewal of our commitment to international criminal justice and to the fight against impunity. The purpose of this afternoon's symposium is to reflect on and appreciate what we have accomplished thus far, and most importantly, to revive our commitment to the fight against impunity. Following a keynote speech given by His Excellency Judge Sang-Yoon Song, former President of the ICC, we will have two interactive symposium sessions, after which Ambassador Maria Teresa Infante from Chile will make concluding remarks. We have gathered the most qualified speakers for these very important topics today. I look forward to listening to their remarks today. I wish you have a fruitful discussion this afternoon, and without further ado, I present to you our speakers. Thank you.
Good afternoon, distinguished participants. May I begin by thanking the organizers for this opportunity to say a few words based on my own personal experience. The creation of the ICC in itself was a great achievement. I believe that the advent of the ICC and the broader Rome Statute system has changed the way the world has come to think of and respond to the grave international crimes. The ICC's judicial interventions contribute to establishing lasting peace as a key element in reconciling societies and ending cycle of violence. By helping the entrenchment of strong legal and societal norms that prohibit massive crimes and human rights abuses, the Rome Statute system can help us move toward a safer world. However, this is not a task for the justice sector alone. It is a goal that can be achieved only with the simultaneous strengthening of democracy, development, and the rule of law. When 18 judges first met in The Hague in 2003, they were full of hope, pride, and sense of mission to build a permanent international judicial institution. At the same time, there was a clear uncertainty about the ICC's future, mainly due to the strong criticism from outside. However, the 18 judges managed to go through with the establishment of the ICC. Just about 30 years ago, who would have thought that crimes against humanity, war crimes, and genocide would be prosecuted by an independent, permanent international institution, and that investigating such crimes would become the expected norm instead of being a rare exception. The monumental achievement of the Rome Statute is that it set up an entirely new paradigm of international criminal justice, which has made accountability for atrocity crimes an integral aspect of the rule of law that simply cannot be ignored anymore. Now the world knows that perpetrators of the gravest crimes need to be and can be held accountable. In the first place, by national courts, and failing that, by the ICC. There are already signs of a growing deterrent effect of the ICC's permanent presence. Ministers from some African states personally told me that the risk of prosecution by the ICC was a crucial factor that helped prevent a large-scale violence surrounding elections in those countries. Another big achievement is the fact that we have turned the ICC from a court on paper into a leading actor in the area of the enforcement of international justice. 123 states have so far ratified the Rome Statute. The ICC has active cases at all stages of proceedings. All triggering mechanisms of the ICC's jurisdiction have been activated. There is now a large body of jurisprudence on many fundamental legal issues. And I am proud to say that the ICC judges have successfully safeguarded the procedural fairness as a cornerstone of the court's integrity. Whoever has closely followed the ICC trials will have seen that the judges are truly independent and impartial, and they're the ones who have the last say in the courtroom. Another great achievement of the statute is the strong emphasis it places on the victim's position. It allows victims to be substantially integrated into the ICC's proceedings, even when not called as witnesses. The statute is mindful of the particular interests of the victims, including women and children. In the countries where the court has active cases, the ICC's outreach program communicates actively with the local population, informing the victims of their rights and helping communities generally understand the ICC's mandate and proceedings. The statute directly mentions the relationship between the ICC and the trust fund in the case of court-ordered reparations following guilty verdicts. The fund also has a mandate to assist the victims outside the context of the court proceedings, and it has already supported tens of thousands of individual victims and their affected communities. As the president, it was my hope that the traditional entrenchment of retributive justice could be expanded to include restorative as well as reparative justice. By adopting the Rome Statute, states established not just the court, but an entire system of new international justice. The architecture of the system splits the responsibilities whereby the ICC carries out judicial work, but enforcement is devolved to states. Therefore, the ICC will investigate, prosecute, and try crime suspects. But states must assist the ICC for arrest warrants to be implemented, evidence to be provided, witnesses to be protected, and sentences to be enforced. Cooperation remains an area of vital importance to the ICC's function and the judicial efficiency. Most of the time, states cooperate with the ICC, but not always, and the lack of cooperation can seriously diminish the ICC's ability to deliver justice. We should not forget that cooperation with the ICC is a treaty obligation, and it must be treated as such. However, the need for cooperation goes far beyond the above-mentioned technical issues to the political support that the ICC requires. This is nowhere more evident than the referrals of the situations by the Security Council. In the Sudan and the Libya situations, no one has been arrested and tried by the ICC. In June 2012, 4 ICC staff were detained in Libya while on an official mission. It took me 26 sleepless days and nights to get their release through intensive negotiations. Unfortunately, the Security Council has not provided the ICC with the help it needs to discharge the mandate given to it in the Security Council resolutions. A far more consistent and vigilant approach by the Security Council is needed. There is also a financial question that requires attention. The Rome Statute and the relationship agreement between the ICC and the UN anticipate that the UN shall help fund the costly investigations and prosecutions arising from the Security Council referrals. Yet, in both Sudan and Libya situations, Sudan and Libya resolutions, a provision was added prohibiting UN funds from helping the ICC. This means that states parties have picked up the bill for the work done by the ICC stemming from a Security Council decision adopted on behalf of the entire world community in order to preserve peace and security. This conflict will need to be addressed in the near future, and I cannot see it resolved easily without a constructive approach by all countries on the Security Council, including the United States. Cooperation should come to be regarded as routine, not an exercise of extraordinary political will. This applies to states parties and also states not yet parties, since the ICC has no tools to enforce its own decisions. Priority needs include the arrest of suspects and agreements on the relocation of witnesses, enforcement of sentences, and the situation of released persons. As president, I diligently contacted many states parties to conclude these agreements, but with limited success. It is now up to the states who created the ICC to identify actions that can be taken. It is my hope that the ICC will consider, as a matter of priority, how they can best use the political and diplomatic tools at their disposal to bring about cooperation. The fundamental principle underpinning the ICC is a complementarity. Under this principle, the ICC does not replace national courts, nor does it have the ability to override properly functioning national courts. The ICC is a court of last resort. This principle has a number of powerful implications. First, it means that every state joining the Rome Statute can be confident that states retain the primary jurisdiction to conduct proceedings for any ICC crimes. I cannot stress enough that this is both the right and the responsibility of each state. Unfortunately, the fight against impunity can only succeed when the national justice system of each state is strong enough to stand against atrocious crimes. To strengthen national justice systems, there are domestic laws to amend, judges and attorneys to train, and penal systems to improve. Yet, only about half of states parties have adopted implementing legislation. I raised these and other needs with the court many partners and tried very hard to strengthen relationships with the regional organizations, states, and NGOs. Tremendous work is already being done to provide expertise, training, and material resources. However, more can be done to coordinate the different activities, to raise awareness of opportunities, and to mainstream international criminal law throughout the rule of law programs. This notion has recently attracted a lot of attention in the ASP. The ICC will only ever be able to handle a small number of cases at a time. More must be done to ensure that national courts are willing and able to act. The ICC has very limited ability to assist the states that lack in developing national capacity. The bulk of work will therefore fall to the court's partners, such as the UN, EU, international agencies, regional organizations, states, and civil society. The ICC is only one piece of the puzzle. There is also increasing awareness of the need to involve development agencies in helping the strengthening of the national justice system. The court's jurisdiction is not universal. The court only has jurisdiction over nationals of state parties or crimes committed on the territory of a state party. As the ICC president, one of my main priorities was to visit and persuade as many states as possible to ratify the Rome Statute. The number of states parties then was only 110. My target region was Asia in particular, as I come from the region, and the region is most underrepresented. Only 14 then. I realized through my trips that states that still suffer from the wounds of war are rather reluctant to join the Rome Statute system for fear that their leadership might be subject to the ICC prosecution for the atrocities that some leaders in power had allegedly committed. To dispel such suspicions, I emphasized over and over again that when a state ratifies the Rome Statute, it applies from the date of joining onward. In other words, if a country joins, the Rome Statute would be a safety net for their future. Many states remain strongly suspicious and skeptical of this legal reality of non-retroactivity. I traveled to many states whose governments were actively considering a sovereign decision to adopt the Rome Statute. The court does not lobby them, but it can provide information to ensure that policy decisions are based on facts. On these visits, the court benefited greatly from partnerships with the EU, state parties, and civil society. It was through just this type of partnership that together I managed to expand the reach of the Rome Statute. My persistent efforts for universality met with a fruitful result, 14 more ratifications, which is a significant achievement. The ICC is an institution independent of the UN system or any other political organ. The independence of the court, it's 18 judges, and the prosecutor is protected under the Rome Statute. The ICC is politically neutral and judicially independent, but the world around us can be very political, and political matters should best be left to the states and such political venues as the Security Council. The court should be able to rely on the states that created it to shield itself from political winds. The court relies especially on the legal community to speak up on behalf of the rule of law and to defend the law from interference of politics. The ICC's activities cannot be turned on or off according to the availability of funds or changing political priorities. Once the judicial process starts before the ICC, it will take its own course. Although my continuous efforts contributed significantly to the strengthening of the ICC's relationship with the host states and the states parties, I believe that the relationship between the court and the states parties would have to be more streamlined. In addition to the initiatives taken by the President and the judges for amendment proposals, states parties also created the roadmap to streamline discussions on amendments. But frankly, it has made the whole process very cumbersome and difficult. It worked very well in the first year, where amendments were limited. But then, states told the court to increase the number of amendment proposals with which the ICC complied. Everyone knows now how they ended. The court submitted proposals well ahead of time, but in the end, the ASP could not adopt them because the Assembly sticks to consensus rather than vote on them. To be honest, many states parties do not have the expertise to deal with the rules of procedure and evidence amendments. Since then, the court has leaned more toward a practice improvement instead of amendments to the legal framework. It is most important that states parties encourage each other to do more for the Rome Statute system, rather than, say, micromanage the court. States parties' engagement on issues related to the court has gradually become more formalized through more facilitations and subsidiary organs of the ASP. Still, ASP should request far fewer reports and let the court focus on its work. Lastly, two areas of weakness in the Rome Statute should be highlighted. One, more effective procedural and substantive means to address states parties' non-cooperation should be devised under Article 87, paragraph 7. Two, a practical solution for the situation of acquitted or released persons needs to be found, especially when that person refuses to go back to their own country. In closing, there are many challenges: competing interests, limited resources, political opportunism, cultural differences, different visions, and so on. But at the end of the day, there are also undeniable shared values and common goals that humans everywhere hold dear. Men, women, children everywhere want to live in a world of peace, security, and harmony without fear of violence and suffering. The international arena in the 21st century is very dynamic and crowded by various international organizations and more. The ICC should encourage the next generation of leaders and actors to always aspire for universal criminal justice, as the ICC will continue its mission from now into the future as a giant leap forward in the global fight against impunity. Thank you very much.
Thank you very much. I would now like to invite the first panel of the afternoon to proceed to the podium. The panel will be moderated by Ambassador Branduza Predescu of Romania, and I also invite the panelists Professor Fausto Pukar, Ms. Laker Joyce Ochen, and Ms. Lorraine Smith van Lin to step forward. The first panel will discuss the impact of the judicial process, and I would like to give the floor to the moderator to introduce the panelists.
Thank you very much. So we're speaking without a mic, or is it? Thank you so much. Ladies and gentlemen, I will first of all apologize to the court, to the esteemed judges, because I'm placed somehow with the back to them. It's not intentional. But what is intentional is to have definitely this first panel of this afternoon. It is, I admit, not easy to speak directly after the very impressive keynote address of the twice former president of the court that we are actually celebrating today. An anniversary is always a good time, as has been shown by the former president, not only to reveal and to highlight the accomplishments, which are many, and are indeed, as he termed them, absolutely monumental, but also to dwell on the challenges, and these are quite a few. From this bird's eye view perspective of a judge with a lot of experience who has actually contributed to make the court what it is today, namely a fundamental cornerstone and the pillar of the international system of administering justice, we are turning in this first part of the afternoon to, I think, the ones that for which or on behalf of which this court has been set up and is doing justice to the victims of atrocious crimes under the Rome Statute and to the communities that have been most affected by these. I am very pleased to introduce the panelists that have accepted the invitation to be here today. They, I think, represent by their very distinguished and distinctive experience three phases of administering international criminal justice, but also dealing in very practical terms with the situations that come under the attention or are being referred to the ICC. Let me start by introducing the first speaker, Judge Fausto Pukar of Italy, although I am convinced that his name resonates with everybody in this room. I will just point to a few of the functions that he held. No, I need to say this, Professor. You have limited time to speak. The moderator is not exactly... so I've been told. But to say a few words about Judge Fausto Pukar, he's been a judge to the International Criminal Tribunal for the former Yugoslavia and its president. He's been member of the Appeals Chamber of the International Criminal Tribunal for Rwanda and worked there until its closure. He has been also, and still is, I think, judge ad hoc of the International Court of Justice, chair of the Human Rights Committee of the United Nations, and president of the International Institute of Humanitarian Law in Sanremo, Italy, and many more other things. But I would stop here, and Judge Onorevole, the floor is yours for about 5 to 7 minutes. These are the rules of the game, I've been told, and I also inform the other speakers about this. So please.
Thank you very much, Ambassador. And let me first thank for inviting me to this panel and to this event, which is, I welcome really the opportunity to consider what the court has done and what could do in the next years to improve international criminal justice. Let me start by some criticism that I heard and built on that, actually, because we should be as constructive as possible in the. And one of the frequent criticism I hear for the court is that the court did not meet the expectations that the stakeholders and the wider group of affected communities, victims, had when the court was established. And also that this was possibly due to the complexity of the procedures, was due to inaccessibility of trials from the interested communities, and in general to reach the international community. And I don't dwell on the criticism as such, but I would like more to be constructive and say what could be done to counter this criticism that emerges here and there. I heard it from several sources. So I think we need an answer. We can answer to this. There are various arguments, but more than answering, I would look to what could be done more in order to reach the person. And I would do it taking into account the principle of complementarity. It has been dealt with the principle in many respects, but there is one respect in which, to which I think the attention has not been put enough. And that's it, that if the position of the court, the function of the court is complementary, the primary responsibility lies with state. We agree with that. That is something that was already decided for war crimes in the Geneva Convention. The primary responsibility is on states. So it's not new in a sense, but at the time there was not a court, of course. And does this give a special responsibility to the court to make it case law accessible not only to the worldwide community, but to the local communities? Because indeed, the court steps in when the local community, the local state, is not able or is unwilling to exercise jurisdiction. So the court is not just an international body, but should take into account also its internal function, and to work for the community that in a specific case is coming to its attention, because after all, is also a local institution of the social community where it works. On one hand, there is the function of guiding international justice. On the other, it replaces domestic judges that, of course, will work for the local communities. And if one takes that into account, the first thing is to make the decisions accessible and understandable. And there I have the feeling that the complexity of the procedures, the length of the procedures, do not make them completely understandable to the people. Because common people will not understand why it takes so long, why it comes maybe at the end of a long procedure to acquittal, why it's the decisions, for instance, sometimes made on small technical points and not on the substance of the case, which for lawyers is an obvious thing, but not necessarily for the common people. And I think an effort should be made in that respect by the court itself. Of course, there are many other issues concerning the accessibility. Many depends on the states parties, of course. States parties should find a way of bringing the local communities to a better knowledge of the activity of the court. The court is distant in terms of space. It's far away. And it's not easy that the ad hoc tribunals had the same problem to make the cases accessible to the court. But I think that in dealing with the case, in writing cases, one should be more, I don't have the time to make examples, but for instance, a procedure that has, rightly so, more guarantees at the time of the confirmation of an indictment, which the ad hoc courts didn't have. It was very quick, the confirmation of the indictment, without guarantees. There is a chamber now on this, and that's fine, but with a possible appeal to that, and that's also fine. But people would not understand why, for instance, the confirmation of indictment should have the length of a judgment. It's too much. It's clearly not understandable why it should not stop at the level of prima facie and not go too much into details. But just an example. I mean, the court could try to simplify the procedures, but here I join also the President Song, because I have the feeling that the power of the court to amend rules of procedure and evidence according to the practice of the court should be increased. It worked well with the ad hoc courts. Maybe they had too much power in that respect. But here I feel it's too much restricted. And it goes to the ASP, which is not made necessarily by lawyers that can really appreciate the court. So I will stop here for this moment because I see my time is gone. My 5 or 6 minutes seem to expire. So I will not go to the other point I wanted to make, which is the universality. What can the court do for making the decisions more universal? And I think the court should give more weight to the possibility it has under Article 21 of the statute to make use of customary law. Because when one remains within, strictly in the statute, is in a treaty position, in a treaty delimitation. And the states that are not parties, jurisdictions that are not parties, will not take care of that case law because it's case law under a treaty. State is not part to a treaty, so it's not really interested in what happens there. If a decision is taken also with the strength of customary law, the decision is more universal. And I think the court should think of using more customary international law. It's allowed to do it, but should do it more. There are signs that it goes in that direction because the last cases have some more weight, put more weight on customary international law, but it should do it more because, after all, the legal framework of international justice, if you want to take all the world, is based on customary international law, as of Nuremberg. So it's better not to fragment too much international law. The court has the possibility of making use of customary law. Let's, if I would advise my colleagues to do it more than they did up to now. Thank you. These were just preliminary considerations.
Thank you very much, Judge. Indeed, only preliminary remarks, but you have already raised a number of questions that I hope very much that in the discussion, the ensuing discussion, after we have heard the other two speakers, will be addressed, because the composition, if I look in the room, of the attendance comprises indeed personalities, I think, ready to step in and address at least two of the issues that you have raised with regard to the functioning of the court. But let us now proceed and continue. It is now my pleasure to introduce our next speaker, and with her, Ms. Leika Joyce Osen of Uganda. We are going directly to the tough reality of the victims, because we are here to speak about the impact that the ICC is doing has on victims of atrocious crimes under Rome Statute and their respective communities. Leika Joyce Osen is a trained trauma counselor. She's working in northern Uganda, and for the last 15 years, she has been working with the victims of Lord's Resistance Army rebels in the area of rehabilitation of these war victims. And now she is currently working in a rehabilitation center in Gulu, also in northern Uganda. It is maybe also interesting and important to note that this center is supported by the AVSE Foundation through funding from the Trust Fund for Victims. And its goal is to improve the quality of life of physically and psychologically harmed victims of war in northern Uganda. A few more words on her work, because this is all very impressive. As a program manager and a trauma counselor in the Trust Fund for Victims project, Mrs. Osen, together with the rehabilitation team, conducts outreaches and follow-up of the war victims in their community. She has seen lives of her clients, so to say, being transformed in the positive sense, hopes restored, and many of the ones that she's been working with, but she'll tell us more about it, have been reintegrated in their communities and have started again a normal work, or what should be a normal work. The floor is yours, please.
Thank you so much. I'm so privileged this afternoon to share my experience working with the Trust Fund for Victims. I've already been introduced at length, even the activities that as a project, Trust Fund for Victims, and my organization, AFSI, we do. Trust Fund for Victims came in to support AFSI Foundation in rehabilitation of war victims in northern Uganda since November 2008 to date. Of course, we have been having year extensions. Our activities is majorly in physical and psychological rehabilitation. Under physical rehabilitation, we look at persons who have lost limbs due to war, those who were mutilated, those who had gunshots and lost their limbs, landmine, to name but a few. So we have a center in northern Uganda that was built by AFSI Foundation in the past using donor funding. And this center, since then, right from the moment that Trust Fund for Victims came in to support us, is being fully funded by Trust Fund for Victims. I am proud to say that this center has progressed from what was originally referred to as an orthopedic workshop now to a fully fledged rehabilitation center. It is under Ministry of Health, because AFSI eventually, after some years, handed it over to the Ministry of Health in Uganda, much as the support, 90% still comes from AFSI. So we have various units that provide rehabilitation to these victims. We have the trauma department, to which I belong, the physiotherapy, the workshop itself, and other cadres like the social workers. I want to say that in the last 1 decade, we are not just talking about 1 year, 1 decade ago, since we started collaboration with the Trust Fund for Victims, we have seen impacts of the Trust Fund in the community. One other activity that I should remember to share with you is we do quite a lot of community dialogue when we go out. As we go out to identify and assess, as an outreach team, we don't work in isolation. We work with the local government structures and the community to identify these victims. I want to say that I wouldn't want to talk about figures, because anyone can't say so. Figures, I wouldn't want so much to talk about figures. But I want to say that the persons who are living with physical disability as a result of war, or those with psychological harm, in areas where we have worked, have regained hope. Families has been restored. In the past, there are those that lost their limbs and their spouses for one reason or the other that left them. But after seeing someone already working and is able to produce, is able to provide, is productive, there's always a reunion. I want to say that when we talk about impact and we talk about our area of coverage, northern Uganda is very wide. I wouldn't want to say that it is only northern Uganda, but even eastern part of Uganda. For the case of AFSI, we are only in Acholi, Lango, and Ajumani districts. But we have partners of the Trust Fund for Victims who worked in some of the districts where we do not work. And with the little resources, we tend to refer in and out so that we are able to maximize the resources, so that each and every victim is able to access support, the quite needed support from the Trust Fund for Victims. As we talk about impact, I shouldn't forget that there is enormous need outside there. As an organization, we can't do everything, and I believe that our partners, some of them are here. Lynn, I think she'll have time and talk more about it if time permits. As we go out in the community, and during community sensitization, and we give a call for who to be registered to benefit from this project, we see the high demand. Women who suffered sexual gender-based violence, and even men. But outside there, it may be very difficult to tell that this one has been psychologically harmed during the war. It's like someone who is walking as a thorn in the flesh. You see the person limping. And you say, this one is limping. What's wrong with you? Why don't you go to the hospital? But if you sit down with this person, and then this person starts to open his or her life, then you will realize the magnitude of this problem. But as a project, or as a trauma counselor, it becomes very challenging. Because I want to say that in northern Uganda, we don't have many of these mental health staff that can provide counseling to the victims. So the few who are there, as we go into the community, at one moment, you can only enroll a handful. And this handful, you have to take them through a series of sessions. Because these are people who suffered atrocities during the war. There are people who even up to now tell us they can't slaughter a chicken because when I see blood, then it reminds me. And you see persons start to react. At one moment, we went to a community to make a follow-up on a woman who was abducted, raped, gang raped, in fact. So when we reached there, we started to talk to this person. And all of a sudden, the woman drops a baby to me. I am lucky that I'd gone with another counselor. So when the woman dropped the baby, she was like, now started to react. She was like, she's in the past. She's seeing images. She's seeing people holding pangas, someone trying to shoot her. Until after some 5 or 6 minutes or so, with intense interaction with the counselor, for me now I became a babysitter. That is when this woman was like, what are you people doing here? At what time did you come? So the person was having flashback. So there is so much frequency of these flashbacks and nightmares of events suffered in the past that it limits functionality of these beneficiaries in the community. I want to say that there is still need for continued support for people in the community in northern Uganda. I shouldn't forget about splinters and those with post-born contractures. Even up to now, after the war, how many years ago, you find someone has a wound that has not healed, has become chronic, and requires surgery. And yet surgery is also very expensive. What do we do as a community and as a project? Many people outside there are not yet reached. I want to talk about continuity and sustainability. I talked about this rehabilitation center in northern Uganda. These legs, these artificial legs, artificial limbs that is given, it breaks down over time. For an adult, in 2 to 3 years, a person needs to come back for a replacement, and a child every 6 months. What happens if this victim comes back to the center and is not able to get the service that he or she needs? The cycle continues. Someone will get re-victimized, traumatized. So there is need for continuity and sustainability of this center. At this moment, I want to encourage the support of the government of Uganda through the Ministry of Health so that there's improvement in access and then improvement in medical rehabilitation facilities and, of course, increase the number of mental health staff who can really benefit or provide the required services to our beneficiaries. I want to appreciate the Trust Fund for Victims, the state parties, the private donors, and the individuals for the support to the Trust Fund over the years that has made the victims of war in northern Uganda although it is a small percentage, that they are able to have hope for tomorrow and to regain life. On behalf of the victims of war in northern Uganda, I would like to appeal to the House that rehabilitation is a collective effort. We need the support such that we may help the victims of war in northern Uganda. I have not talked about children born in captivity. Remember, they are no longer children. They are adults. When we go for community dialogue, there is always a question. Where do they belong? Whose responsibility is it? What do we do as a community? Thank you so much.
Yes, thank you very much, Joyce. Very impressive project, very impressive what you are doing there, together with the team in the project. But if I just may drop in a comment, the situation in these communities in northern Uganda is just one situation of, unfortunately, others. But this story, so to say, can be illustrative, I think, for the purpose of this afternoon's discussion. Before going over to discussion, last but definitely not least, we have one more very impressive speaker with us. Thank you very much also to Lorraine Smith van Lin of Jamaica, who has joined the round. And she will tell us about her very interesting experience that has taken her from defense as director for the International Criminal Justice Program of the International Bar Association to working today as post-conflict justice advisor of the Hague Office of Redress. So before joining Redress, I have just mentioned her very important experience in the IBA. And thereafter, she was a consultant specializing in international criminal justice and, again, human rights. She has also taught international criminal law at the Hague University here in the Netherlands, and she has also worked for several years as a prosecutor and resident magistrate in her country in Jamaica. And an important part of her experience was to be part of the Justice Reform Task Force responsible for the review of the justice system in her home country. Now, I would like you to tell us, Lorraine, from your perspective of redress counselor, but also from all other perspectives in your very full life. Please.
Thank you, Ambassador. Thank you very much, Ambassador. And good evening to this very distinguished, well, we're not quite at evening yet. I think we're still at afternoon, to this very distinguished audience. It is truly an honor on behalf of Redress to speak to everyone here, but I speak not only in my capacity as a staff member of Redress, and Redress is a human rights organization that works to ensure justice for torture victims. It was actually started by a torture survivor, and we work for victims. We focus on victims, and we work directly with victims organizations, particularly grassroots organizations. But I speak also in the capacity as facilitator. Redress facilitates the Victims' Rights Working Group. So my other colleagues who are members of the Victims' Rights Working Group, Amnesty International, Human Rights Watch, Avocats Sans Frontières, so many other parliamentarians for global action, so many others who are not seated here, but who work directly with victims and who are part of the Victims' Rights Working Group. I speak not on their behalf, but I want to include them in my intervention this afternoon. I must confess that I am so moved by what Joyce has said because of some work that Redress is currently doing in Uganda at the moment. I am moved because I remember recently being part of a victims forum, And at the table was a member of a local grassroots organization. What I didn't know was that person who spoke was also a former child soldier. She had been abducted. And it was not until I heard her intervention that I realized that our meeting was not only to speak from a rhetorical perspective. She asked a very simple question. How do I move on with my life now? What can I really do? What can the formal system of justice do for me? And that is the question I believe that on this 20th anniversary of the Rome Statute, we are going to have to ask. Victims, whether they be in Uganda, in Afghanistan, in Palestine, in Georgia, wherever they are based, are asking the question still. Given the fact that the preamble to the Rome Statute clearly starts by saying that as the international community, we are mindful of the fact that millions of persons, millions of victims suffered unimaginable atrocities that shocked the very conscience of humanity and prompted the international community to act, to say never again. With that in mind, if we bear that in mind, the broad question, the question that still remains is, 20 years after that event, what exactly does the ICC mean for victims? Is it merely a question of numbers? Is it a question of budgets and figures? Is it a question of expectations and rights? I would dare say, ladies and gentlemen, that it is more than that, so much more. I will be very brief, I hope, in my intervention since we have 5 minutes. My focus will be on 3 areas where I believe that the court has made some strides, and very important strides in terms of recognizing, respecting, and seeking to enforce victims' rights. The court has quite an elaborate participatory regime, and that is important for victims. The idea that victims recognize that the ICC exists and has the potential to enforce their rights is something that we should never forget. I tell you why this is relevant. When we begin to look at the states that are now implementing Rome Statute legislation, a number of them are doing so carte blanche. So the Rome Statute provisions governing victims are also incorporated at the national level. What we are seeing, however, is that the system as it now obtains at the ICC in terms of how victim participation is interpreted and is evolving does not necessarily translate at the national level. So I give you an example. The International Crimes Division of the Uganda High Court has, by virtue of the rules of procedure and evidence, implemented the Rome Statute provisions governing victims' participation. The question is, what does that look like in practice in a common law situation? What do you do when in a common law context you have the traditional defense lawyer, prosecuting counsel, but you also have now a set of persons, victims lawyers, with a dossier with 98 victims? How does the court manage that at the national level with limited resources? These are some of the questions, the practical questions that arise. And this is in relation to participation. Victims also have the right to protection. At the national level, that translates again into more challenges because very often national systems have very little capacity to have the kind of large-scale protection mechanisms that the ICC currently enjoys. Nevertheless, the ICC does have a standard-setting responsibility, and I use the word responsibility advisedly, but I do believe that the ICC has standard-setting potential. Whatever the judges determine in terms of the modus operandi in relation to protection, in relation to participation, engagement with victims, will also inform how things operate at the national level. And I think that is an important issue to consider. But we are mindful that when we are speaking of victims, there are three issues that jump out constantly. There was a particular terminology used by the Bureau of the Assembly in, I think, 2013 in a report. The Bureau says, and I'm looking for the quotation because I found it quite important, in its report on victims and affected communities and the Trust Fund for Victims, the Bureau said, quote, there is a need to close the gap between expectations, rights, and resources. In other words, while stakeholders should bear in mind that victims' rights are a cornerstone of the statute, and therefore the debate on victims cannot be reduced to a cost driver, they should be aware that the world is still facing a financial crisis that has consequences in terms of the allocation of resources. As a result, said the Bureau, finding that balance is a matter of priority. Expectations, rights, resources, three distinct concepts of which a common ground cannot seem to be found. I prefer to begin the discussion with rights, because if we look at victims' issues at the court, primarily through the lens of resources, I would submit that we start at the wrong place. If we start with the premise and with the understanding that these rights exist and we should take whatever steps are necessary to give meaning to those rights, I believe that we can then find ways to adapt processes and procedures to ensuring those rights. Sounds very good, but sounds quite rhetorical. However, I believe that the court has itself, in the evolution of its understanding of victims' participation, has begun that process. It has moved from a 17-page, very cumbersome case-by-case approach to participation to a one-page application form. The problem isn't solved. We are still going to have to see how that translates in practice. We moved to outreach. A very encouraging decision was issued recently by the pretrial chamber in the situation in Palestine. It was quite interesting to hear the chamber very clearly said, the participatory rights of victims raise questions about the timing, consistency, and sustainability of the ICC's engagement. And the chamber made it clear that the ICC has a responsibility to engage from very early with victims. That, I believe, is a step in the right direction. In fact, the chamber ordered the registry to establish a system of public information and outreach activities among the affected communities, and particularly the victims of the situation in Palestine, and directed them to establish a continuous system of interaction between the court and victims residing within or outside of Palestine for as long as the situation is assigned to a pretrial chamber. The question is, what will that look like in reality? When we speak about for as long as the situation in Palestine is assigned to a pretrial chamber, if we look at our previous experience with other ICC situations, that could be for a protracted period. What does that translate to in real terms? And what systems will the registry have to put in place to sustain this flow of information, even if it takes years before an investigation proceeds to case stage? And thirdly, will this be replicated in other situations? I will end with reparations, and I know I've gone over 5 minutes. I asked you to forgive me. But let's think about reparations in our discussion. There are real limitations to the number of victims who can and will actually benefit from ICC reparations. But reparations are a legitimate expectation of victims because the Rome Statute provides for it. The question is, when you have OTPs charging policies that limit the type of victims who can benefit based on the crime charge and geographical focus, there will be limitations. Secondly, when the conviction or acquittal that itself could limit the type of victims who can benefit or may exclude certain specific victims. Thirdly, certain types of harms may be excluded from the reparations order. For example, if there is lack of proof of a particular type of harm. Several recommendations have been made by experts, and it would be interesting to hear in our discussion what others think of that the Rome Statute system should be delinked from the requirement of a conviction of the accused to allow victims to focus more effectively on establishing the harm done to them. I haven't come to a conclusion, but it would be interesting in the discussion. The reality is that the majority of defendants at the ICC are found to be indigent. So the burden falls on a trust fund that at the moment appears to lack the capacity and the resources to implement reparations. So that brings us to the assistance mandate, which is still underfunded. I leave you with these thoughts. Firstly, focus on the rights. I know this sounds very much like a human rights law lens. Secondly, engage victims earlier in the process. Clear messaging helps to manage expectations. Thirdly, synergize. Different sections of the court working with victims can pool resources and expertise to ensure greater efficiency. Fourthly, support the trust fund's assistance mandate to reach a larger number of victims excluded from reparations. And finally, share the burden among states for making reparations effective. I am a big fan of an investment in national reparations programs to ensure that those who are not caught by the ICC net can nevertheless obtain reparations. I'll stop there. Thank you very much.
Thank you very much to Joycelyn. So we have heard now three perspectives that are in a way very different, but definitely they complement each other in a very propitious way if we go back to the topic of this afternoon's first panel of the symposium. So we have had the perspective of a judge, we have had the perspective of a practitioner working with victims, and of a victims' rights defender. In this capacity, you have spoken to us now, Joycelyn. There have been interesting questions raised, and I had the feeling, at least in the end, that Joycelyn was throwing some of the questions back to you, distinguished ladies and gentlemen. And now, before giving maybe the floor to all of you to profit by the presence of the three distinguished speakers, I may even ask them if they would like to ask questions to each other, because they come from such, in a way, different avenues of dealing with international criminal justice. Any question to each other right now? Or a comment or comments or questions, please?
Just one small comment to endorse what has been said by my colleagues, especially the focus put on the victims' rights. You said it's a human rights perspective, and I agree to it, but I think that the whole problem of international criminal justice is a problem of human rights at the end. And one has to take the human rights focus. It's after all, the international community exercising criminal justice is adding a layer to the protection of human rights. This is the purpose which the human rights instruments target the state. But what happens with the perpetrator, specific perpetrator, is left to the state to decide whether to punish him or not to punish him. Targeting also the individual who materially or behind the scenes is responsible for the crime is in fact an additional layer of protection. And this goes essentially to the victims.
Yes, thank you very much. I am looking to you and inviting you to make comments, to address questions. There have been remarks here also on behalf of Judge Pukar about how he would see the court maybe to amend, improve its own ways of working, to maybe shorten the lengthy procedures sometimes. Always speaking, at least in this panel, from the perspective of affected communities and victims. But let me maybe come back to what has been said in the keynote address and bring you from the human rights perspective, which is very obvious, back to what former president was mentioning, namely the rule of law, because administering international criminal justice is finally now a solid pillar of rule of law. I'm looking to the audience, and please do in the.
Thank you very much to the panelists for this very interesting discussion. My name is Linde Nutte. I'm the director of CISVS Uganda, and we're an NGO providing psychological rehabilitation under the Trust Fund's assistance mandate in Northern Uganda. So I would like to accept Joyce's invitation to also extend a bit more on some of the points that she mentioned, and more specifically on the need to further psychological rehabilitation for war-affected individuals, families, and communities. And in this regard, I first of all want to commend the ICC and the Trust Fund, because it elaborated its assistance mandate in Northern Uganda based on 3 areas, namely psychological rehabilitation, physical rehabilitation, and material support. And the brave choice to incorporate psychological support services for victims and their families is very vital for their recovery and rehabilitation. And although mental health poses an increasing burden to global mental health, and we know that mental health problems also spike during and after context of armed conflicts, it's a seriously underfunded sector, and leading victims who are experiencing mental health problems due to armed conflicts and their families as well to suffer in silence. So even more than 10 years after the conflict in Northern Uganda, we still see the long-term and intergenerational effects of unaddressed psychological needs and social needs of victims and their families. And to address these needs from our work as CISVS, we have seen that a systemic approach, a systemic point of view, including individuals, placing individuals within their context, within their families and communities, has worked in order to properly address the bidirectional nature of rehabilitation. And for example, also to address social issues regarding rehabilitation, such as stigmatization and re-victimization of certain groups of victims, such as former child soldiers and victims of sexual and gender-based violence. And specifically, although the assistance program in Northern Uganda has already reached to many beneficiaries, as Joyce also mentioned, there's still a huge need, and there's still so many beneficiaries to be reached. It's been, to talk a bit about numbers, it's been estimated that up to 35% of people in Uganda experience mental health problems, but only 10% of them are reached and are supported psychologically. And to address these enormous needs, again, to emphasize on what has been said by the panelists, I feel that the only way forward is to work together with governments, international institutions such as the ICC and its trust fund, civil society, community leaders and stakeholders, and most importantly as well, victims and families themselves. So thank you very much.
Thank you very much, and for all the work that you are doing over there. Would anybody in the audience like to maybe share also such like experiences, maybe working in other communities, in other countries? Yes, please.
Judge Mindua from the ICC. I would like to come back to the issue raised by Madam Lorraine Smith van Leen regarding the rights of the victims. If I understood very well, she said that all victims should see their rights recognized and implemented, irrelevant of the conviction of the accused person. I should say that I am reluctant to that, because I don't see really how this could be feasible. In other words, it means that as soon as an indictment has been confirmed or issued, or as soon as charges have been confirmed, the trust fund could deliver reparations to the victims. It seems to me that there will be a big confusion between reparation and assistance mandate of the trust fund for victims. If we don't put really an emphasis on the necessity of a conviction judgment. Thank you.
Yes, thank you very much, Judge. I think that you would like to reply to that.
Thank you very much, Judge, for that intervention. Just to clarify that in relation to the idea of delinking, and this is something that has been mooted in several quarters. I can recall a few years ago, I think it was in 2013, there was an expert report commissioned to look at the level of efficiency at the ICC. This was also one of their recommendations. And as we've spoken with other persons, there is a view has been presented to us about delinking the idea of reparations, as we've understood it, from the need for a conviction. And the idea would be that you would not necessarily refer to it as reparations in the sense of, in fact, someone called it collective reparations. And the idea was to try to focus more on the harm that the victim suffered, as opposed to this idea that a specific individual would be responsible for paying that back. Now, there was a lot of debate when you look in the history of even how the reparations provisions themselves were included in the Rome Statute, and there are many here, including Professor Judge Pukar, who is much more able to speak to this issue than I could. But what we keep getting back is that because everything depends on a conviction, what tends to happen is that victims could wait conceivably 10 or more years without any form of assistance, without any hope of reparations. And so this idea of delinking, this is the suggestion, it would not necessarily be even called reparations. It would be more a ramping up then of sorts of the trust fund's assistance mandate. So the trust fund could conceivably, like it is doing now, step in to provide assistance. It's very debatable. I understand the challenges around saying that you should have first a conviction. In fact, I think we can be very frank in this room. There are some persons who felt that it was not appropriate for, in one particular case where there was recently an acquittal, in the case of Mr. Jean-Pierre Bemba, that there was a chamber convened to decide the issue of reparations before the decision of the appeals chamber. So let's call a spade a spade. There are some who said it was perfectly logical that the chamber did that because it gave the opportunity for preparations to take place. But then you have an acquittal, and you then have an issue where for some time another chamber has been working on these issues. So the question is, do we link reparations to a conviction? Or do we focus more on the assistance mandate, and then later on, with the narrow reparations that might happen, we see what happens? It's a very interesting issue, and I invite persons to really think about this. If we're going to do it, the Rome Statute, Article 75, would have to be amended. So this is also the challenge.
Yes, please, President. Please, Judge.
Thank you very much, and Ebo Suji here. That is a very, very important discussion that is just happening now, and I think it is important that the states parties need to take very seriously and go back to look at what to do. It is a debate that even amongst judges we have had ourselves, and some of you who followed the jurisprudence of the court have probably read my own views on the matter, where I do worry that that linkage between conviction and reparation can lead to all kinds of confusion. I mean, when we, as judges, render a judgment, there's a standard of proof beyond reasonable doubt before you can convict somebody. As a question of legal liability of the accused for the conduct. But then you're looking at a victim whom you've known that this victim clearly suffered harm. There's no question about it. And I worked at a special court for Sierra Leone where you could see evidence of what happened there. Hands were cut off during the Civil War. So you're looking at that. There's no question this person suffered harm. But then the question is, the accused person in the dock, are they legally responsible for that? Which is a separate question. Now, it's a separate question. Now, when you link conviction, reparation to conviction, you create this tension where if at the end of the day the question is, has the accused person, has the evidence shown prove beyond reasonable doubt, and the question is no, and convicted, all anxieties break loose. Victims are saying, well, are you saying nothing happened to me? Look at my arm here that's been cut off. So this is a very, very important discussion that needs to happen. I have spoken to this in my judgments in the past. There are lots of jurisdictions where you have, in Canada, for instance, where I practiced, there is something called the Criminal Injuries Compensation Board that deals with the question of a reparation for criminal injuries. It's a separate matter from whether or not anybody is convicted. And I believe you have the same in New Zealand and in Canada and in the UK. So I think it's important to look at this thing as part of the lessons learned so far, reflections on the 20th anniversary, and see whether the setup we have is the ideal one or whether something can be done about it. Thank you very much.
Yes, please. Yes. There are some more questions.
Yes, thank you very much. My name is Jens Diekmann. I'm Associate Victims Counsel in the Banda case, representing, together with a colleague from Senegal, 103 victims from 6 different African countries, and I'm the Vice President for Victims of the International Criminal Court Bar Association. And I'm most grateful and fascinated by the discussion because it echoes my experience during the last 2 or 3 years. Whenever it comes to the discussion on victims at the ICC, we are very fast at this point that we have to state and to realize that there seems to be a gap between the statute and the reality, or the feelings, the impressions of the victims and what the rules and the statute is promising. And I can only echo what Lorraine says, and this is really something we should all here think about. And this is something I really would like to use this unique opportunity here to sit together with everyone to talk about what to do. I think the time has come to think about the future of victims' participation at the ICC. And from a counsel perspective, I have to advise my clients about the law and the reality here in the court. But what is the reality based on Article 75? Is it really true that victims can expect everything that is offered to them theoretically in Article 75? Obviously not, we have to state, after all these years. And can it be a fair system that the law offering more than it will be ever able to realize? And this is not fair to the victims, in fact. And as a lawyer, I owe my clients honesty. And I think this court should think about how to review, perhaps, this system. And my personal vision would be that we have, perhaps in 5 years, a review conference about the review of Article 75 and think what happened after the first reparation orders. What are the expectations of the victims and how have this been fulfilled? My vision would be that dealing with victims shall not finish with the reparation order. The court shall be in continuing communication with the victims and see what the reparation order makes in their life. And perhaps if we see the system is not working, then we have to review the system. And in fact, this process started now. After Lubanga, after the first reparation orders, now we are in a process to review. But I think in some years, then will the moment come where we sit together and perhaps amend Article 75 or to change, to adapt the system to the real needs of the victims. Thank you very much.
Yes, thank you very much. I've seen some other hands raised. I would take maybe 2 more questions and then, of course, reaction from our speakers, and then we'll have to close. Please, second. Yes, please. The lady.
Thank you. I'm Yasmin Zaiter from the Ministry of Foreign Affairs of the State of Palestine. I, of course, would like to first thank you all for your eloquent interventions. The focus we would like to take is on the balance, as you mentioned, of victim participation, victim rights, and the financial aspect of all of these. We, of course, welcome the decision that was taken by the pretrial chamber with regards to the outreach mechanisms that should be implemented, specifically in regards to the situation in Palestine. I think a lot of times victims feel alone, and besides implementing this outreach mechanism, it also provides the victims with the sense of the presence of the court, which is very important, especially in a situation like that of Palestine, where the crimes continue to be perpetrated and where the number of victims only seems to be increasing. The longer, the more that the decision to open an investigation is delayed. So my only concern is that while education and outreach is very important, victims require and request, most of all, to be heard. And providing that mechanism, I believe, especially at this phase of the proceedings, and especially in the situation of Palestine, is crucial.
Thank you. And the other question or comment, please.
Yes, thank you very much. Thank you for these insightful comments. My name is Caroline Buisman, Defense Counsel. I still am on the Katanga case, which says a lot because this case started in 2007. And one of the reasons this is still going on is because of these very, very long reparation procedures. So I also wanted to say this is a very important debate. And from the defense perspective, we even had a panel and a training on this at the end of June here at the ICC. And I really know that it strongly is the view of Defense Counsel that the separation would be very good for everyone, also for defense, also for, like, if we talk about expenses, because we are involved all these years because 1 million is allocated to defense, the defendant, even though in reality he's never going to pay it. It's a fiction. So I really wanted to say this is a very important comment you made, Lauren. And especially the expenses of all these years that you have to pay defense counsel, victim counsel, you could reduce that length and you could reduce the cost. So I really encourage this debate in the future. Thank you.
Thank you very much. Are there any more comments or questions from the audience? Yes, please, Judge.
Moto Noguchi, the chair of the board of directors of the Trust Fund for Victims. I would like to, or let me try to summarize the understanding of the board of directors of the Trust Fund for Victims on the issues discussed this afternoon. We are given 2 mandates, assistance mandate and reparations mandate. And you have clearly described the dilemma we are in. On the one hand, the RP of the ICC clearly states that all the reparations orders will be issued against the convicted person, which means the notion of reparations order is based on the liability of the convicted person on the very fact that he has been convicted for certain charges. And this naturally limits the range of scope and of charges and range of victims to be benefiting from reparations awards. So at certain cases, in the absence of prosecution or in the failure of prosecution, Trust Fund for Victims try to assist victims using another tool, which is assistance mandate. That one example is, as I mentioned in my speech this morning, recent decision of the board to accelerate the intervention in Car 1 situation after the acquittal of Bemba case. And of course, in all these cases before the ICC, there is a serious time gap of at least years or even 10 years or more than that between the prosecution is made and conviction is reached since the crime's occurrence. So in this regard, we continue to depend on assistance mandate by which we can provide assistance without waiting for these prosecution or convictions. And under that mandate, we can reach broader range of victims without being restricted strictly by a limited number of charges. Although I would like to emphasize that assistance mandate is not the tool to compensate the gap of prosecution and conviction, still it is only the powerful tool to fill the gap. So for us, the Trust Fund for Victims, despite the development of reparations regime in the last few years, still the significance of assistance mandate remains very heavily. And that's why I would like to ask the states parties and the international community to keep supporting us to fulfill our both mandates. Thank you.
Thank you. Thank you very much. I would then turn for the last time to our speakers and ask whether you would like to have any reaction or maybe last comment to what has been said from the floor. Well, if This is not the case. Ladies and gentlemen, I would like to thank you for the participation, for the very insightful comments from various very useful perspectives, I think. And of course, to say a big thank you to all our three speakers who have shared with us some very emotionally. Thank you very much for all your work that you are doing on the ground, in the field, working directly with people affected. Also to Joycelyn, of course, for being a true rights defender in the best sense of the word. Last but not least, of course, to the judge who has a huge experience of administering justice. And ladies and gentlemen, my final word goes to say thank you to the organizers of the symposium and to the inspiration they had to elaborate such a topic for this afternoon. Discussion has shown us that it is a very topical one, continues to be a very topical one 20 years after the creation of the court. Our court that is a revolutionary court, it is work in progress, and it is doing a tremendous job for all of us. Thank you very much and enjoy the coffee break. Thank you.
Thank you very much, Ambassador and panelists. We will now break for half an hour, but before we break, I would kindly request that the panelists, as well as those who made interventions, are kindly requested, if they can in a written form, submit their statements. It will be reported if they wish so. And we will now break for half an hour. I kindly request you to be back in the room shortly before 4:30, as we have an element in the program that was not listed, which was interesting to be a part of. The coffee will be served in the lobby, so you'll also have a little bit of a possibility to stretch your legs. See you back in 25 minutes.
We thought it so important to have somebody from outside come in and tell the story. Excellent coordination.